Hi, everyone. Welcome to the GAPABA Solo Small Firms Cybersecurity CLE. We're glad to see people coming and joining us today. We've got, maybe 100 participants, so hopefully it'll be a great group. We've got a wonderful speaker today on a great topic. I've got here with me my co-chair, Jungwook Lee. I'm Alan Chang, one of the other co-chair for the Small Solar Farm Committee, and we've got Daniel Hong, another member on our committee, who was instrumental in putting together this CLE today. And before we go further, I did want to mention that this is our last CLE event, our last small and solo firm event for the year. We've put on another successful CLE as well as a few other events this year. And moving forward next year, Jungwook and I are stepping down as co-chairs, so we are looking for replacement co-chairs. If anybody is interested, feel free to either message Jungwook or I, or email one of us, and we'll provide our emails at the end, and then we can talk. Okay. Daniel, do you want to go ahead and introduce our speaker, Keyaan?
Yes, thank you, Alan. Hello, everyone. Thank you for joining us today. Before I introduce our speaker for today, please feel free to submit your questions during the presentation using the chat feature. And with that, I'd like to say we have an incredible speaker with us this evening, Mr. Keyaan Williams, Mr. Keyaan the Great Williams. He is a leader, a teacher, a mentor, and an author. In the past, he has served as the Acting Chief Information Security Officer for the Worldwide Discipleship Association, as the past president of the Information Systems Security Association, and as a Director of Information Security at the CDC, to just name a few of his amazing achievements. He's now the founder of Cyber Leadership and Strategy Solutions, LLC, also known as Class-LLC. It's a cybersecurity business service firm right here in Atlanta. He's been the honored speaker at the most prestigious conventions in the field of security, and he's here today to discuss managing confidential and digital information as we shift more and more to maintaining confidential client information in our personal devices and the cloud. Through today's discussion, he will guide us through our obligations as attorneys for maintaining confidentiality, the top threats faced by attorneys today, and the how-tos of preventing or dealing with cybersecurity threats. With that, I want to thank Mr. Keyaan Williams for being us today. But before I hand off the screen to you, Keyaan, I was hoping you could share with our audience today something fascinating that I learned from you earlier this week. Keyaan was also a chemical weapons specialist in the U.S. Army. In our prior conversation, we had discussed the recent explosion in Lebanon, and I learned from Keyaan what you're supposed to do and what you're not supposed to do if you're ever in the blast radius of such explosions. So Keyaan, could you share with our audience today what you told me?
Yeah, I'm happy to share. One of the interesting things about being a nuclear, biological, and chemical weapons specialist is that you learn all kinds of interesting information. And so when I saw in the news what happened with the blast, and you see that people are standing up and they're looking into the blast, what the military taught me for responding to a nuclear attack is that you identify the direction that the blast is coming from, and then you lay down, because there are multiple waves that radiate out from the center of the blast. And so there's a light wave, there's a sound wave, there are shock waves, and then for nuclear situations, they also have radiation waves. And so the best way to protect yourself is to lay on the ground in the direction and then cover your head so that you aren't overwhelmed by the number of waves that are coming. And it's an interesting conversation that leads into our topic, because there are waves of attack that you're going to see in cybersecurity, and doing the wrong things can expose you to a lot of risk. And so it kind of leads us into the presentation and part of the inspiration for why we're having this session. I was talking to the Solo and Small Firm Committee at the Georgia Bar last year about all of the risks that we're facing and all of the obligations that attorneys have. And one of the things that the Georgia Bar rightly pointed out was that the profession and the practice of law has specific obligations that all lawyers are responsible for. And so based on my conversation with the Georgia Bar, this conversation is tailored to address Opinion 477 from the American Bar Association, which states that lawyers have an ethical obligation to protect client confidential information when they're transmitting that information over the internet. And then in conjunction with that, Opinion 483 talks about the obligation that lawyers have if there is an electronic data breach or cyber attack. And so everything that we'll talk about for the next hour as part of the CLE and then the Q&A after the fact is related to these two obligations. What is important to keep in mind is that I'm a cybersecurity professional, not an attorney. And so everything that I'm sharing with you today is technically and academically accurate from the perspective of a security person. And so I've taken my conversations with the Georgia Bar and I've looked at what the American Bar Association has available in terms of the recommendations and all of the rules for professional conduct and everything that is associated with cybersecurity, and turned it into a conversation that helps attorneys understand their obligations from a security perspective and make sure that people do the right things, take the right approaches, apply the right practices so that they can protect themselves, protect the data that they have, and ultimately to protect the client confidential information that is in their possession. Now, if we start with the story, there are all kinds of stories that describe the value and everything that's included in the content of our conversation. You know, our roadmap for discussion includes all kinds of things like the impact on social engineering, common types of attacks that happen, defense and mitigation techniques, you know, what is phishing, what is encryption, and how do I deal with these things? But recently in the news, you know, just a few weeks ago at this point, the SANS Information Security Training Organization is one of the most widely known cybersecurity training companies in the world. They have a relationship with the Department of Defense. At the Army Cyber Command in Augusta, they have $1 billion contract to do cybersecurity training for the military, and they have millions and millions of records that are in their database related to their customers, related to their partners, and related to everything else. What you'll discover at the end of the CLE today is that even though SANS had a data breach, what minimized the impact, you know, only exposing 28,000 records and identifying it themselves and not depending upon a third party to tell them that something has happened, are all good signs of a mature security program. And my hope is that at the end of the conversation, everybody listening, whether you're an attorney or you're a business person or you're a professor, that you can take some nugget away from the conversation that is going to help you rethink the way that you're dealing with security, the way that you protect your data. And as an extension of your data protection, you're also thinking about, how do I protect my organization from a cyber attack? And so when you take SANS situation, you know, this is a common attack that everybody's going to encounter. Most phishing attacks are leading to a cyber incident or a data breach because the construction of the phishing attack is meant to cause people to click on the link. And so statistically speaking, since March of 2020, phishing attacks have gone up 650% because of COVID, because people are interested in the content. They're seeking out information. They're trying to find out, what decisions do I need to make? What actions do I need to take? What do I need to do in the midst of a global pandemic? And it makes them susceptible to clicking on fake messages that have the right subject, that have the right title, or have the right content. You know, SANS was very discreet and very transparent in their disclosure, and they provided for people step by step the content of the message, everything that was included in the message, and what happened, not because they wanted to say that, yes, bad things happen to us too, but they wanted people to learn from their mistakes. The benefit of this is that everybody can see now that if you have the right message that comes in at the right time to the right person, even when you're dealing with security experts, you're still going to run into a security problem. And so one of the themes or one of the topics that comes up as part of the conversation is that there's no way to prevent all cyber attacks and there's no way to prevent all data breaches. What we're really focusing on are the steps that are necessary to make sure that the organization can detect the breach, that you prevent unnecessary or unauthorized disclosure of sensitive data, and that you provide good incident response so that you contain the situation and respond as quickly as possible. Now, the silver lining in SANS example is that if you consider an organization has millions, maybe tens of millions of records in their database, 28,000 records is an insignificant number of people who were affected. Yes, people were harmed, but it could have been much worse had they not identified the problem and provided remediation as quickly as possible. And now that notification to 28,000 people is a fraction of what could have been done in terms of the damage that people were facing. And so my question to the attorneys that are listening, and even for people who are in industry and in education, Are you equipped to respond as quickly as possible if something happens? As we go step by step through the content in the presentation, we'll cover specific items that focus on all of the things that you need to do, all of the things that you need to think about, things that you need to be aware of, so that in your situation, when your organization encounters a phishing attack or ransomware, or just the download of malicious information from a website, that you're equipped and prepared and as ready as possible to respond so that the least harm comes to the most important people, your clients, but also so that you stay in business and you don't have problems. And ultimately, you don't have to pay a ransom or you don't have to pay fines because the National Conference of State Legislatures has breach notification requirements that could lead to a fine because of unauthorized access or disclosure of information. Now, when we look at the official details, cyber attacks and data breaches are more prevalent. And outside of the profession of law, what you find in industry is that people say that law firms, hospitals, and education organizations are subject to the worst outcomes from a cyber attack because they have very critical data. The data is also very sensitive. In a hospital, I have patient records. In a law firm, I have all of these secrets about our clients, whether it's litigation, whether it's intellectual property, or whether it's personal injury. Every type of law that you can conceive of, the attorneys are going to have something that is critical to their clients and could lead to a negative consequence for people who are affected if information is lost or if things are disrupted. Our conversation over the slides is going to focus on, again, the things that you need to take care of, but specifically we want to talk about data classification, how data classification is going to help drive the actions that you take with sensitive data versus non-sensitive data, and the importance of keeping your systems up to date because unpatched and unsecure systems are often a gateway to destruction or demise for the organization. Now, verbally, I mentioned two rules that come from the American Bar Association that kind of govern and influence the content of the presentation today. Addressing these rules also allows us to call this continuing legal education. And as a reminder, you'll see a slide at the end. If you are an attorney and you would like to receive continuing legal education for your time today, then through my partnership with GAPABA, we are making sure that that's available. And so to make sure we cover the basics, Formal Opinion 477 says that attorneys have an ethical obligation to protect confidential information. Now, this opinion focuses on the transmission of the data. And so it's internet focused, which is going to bring technology into the conversation. But the scope of that conversation is not limited just to the communication wire. It also applies to the information system that houses all the data, the connection, whether or not you're in Starbucks or whether you're in your corporate office or whether you're working from home, and the entire scope of communications from the origin of the data all the way to the destination need to be considered and need to be evaluated so that you can make sure that the transmission is happening securely. In conjunction with that, Formal Opinion 483 talks about the obligation that attorneys have before, during, and after a data breach or cyber attack, which is directly in my domain as a security executive, because it's very important to think about the preparation phase, the process that you use for incident response, and all of the actions that you take after the incident has occurred, how you provide remediation, and the after action steps that take place so that you can evaluate how did this happen and what am I going to do to prevent this from happening in the future. And when you look at the two formal opinions together, I don't have slides on it, but there is a great use case for the Singapore health data breach. In July of 2000, what year is this? It was July of 2018 or June of 2018. There was a breach of the public health of the healthcare system in Singapore called Sing Health. Sing Health worked in conjunction with the healthcare ministry, IHIS, who is the IT organization responsible for the healthcare sector in the country. The data breach led to a violation of the Personal Data Protection Act, which led then to an investigation to find out what happened. How did this happen? Why did it happen? What measures were failing or were not in place to protect the organization? What they found in the context of the investigation was that the healthcare system did not have adequate resources. They relied overly, or they were overly dependent on the healthcare sector at the government level, and people within the organization did did not know how to respond to a cyber attack properly. Then in conjunction with the failures of the healthcare system, IHIS, as the ministry in charge of the healthcare sector, had people in charge of incident response who did not know how to recognize what an incident was by definition or by the technical evidence that was in the environment. On top of that, the configuration of the environment was such that there was a identification in the report that the people in charge were so complacent about the configuration of security and the management of data that had they taken their duties seriously, then you would not have had the data breach or the outcome that was ultimately produced. And the end result of the Sing Health data breach, and the full report was released in January of 2019, is that 50% of the citizens in the country of Singapore had their public health data exposed and taken out of the country by cyber attackers simply because the right countermeasures weren't in place, the right precautions weren't taken, and when the incident was detected, the response time frame was too slow and was not enough of a priority to prevent the disclosure of 1.5 million records. And so you compare the Sing Health data breach where 1.5 million records were taken, and you compare and contrast that with SANS, which happened just a few weeks ago and only 28,000 records were disclosed. The practices and the procedures and the level of seriousness that you apply to the situation has a huge impact that you ultimately realize in the organization. If we do very well, we may not prevent the breach from occurring, but we reduce the impact on our customers. 28,000 is a much smaller number than 1.5 million. And so as we go forward and we look into the details, each detail that we talk about is going to help everybody understand everything that needs to be done, everything that needs to be considered, the things that you need to put in place to support your organization. Now, again, I said at the beginning that I'm not an attorney, but I have taken the time to read the American Bar Association's Model Rules of Professional Conduct. And inside Rule 1.6, there are two comments that make a difference in this conversation. Comment 18 notes that a lawyer should make reasonable efforts to safeguard information relating to the representation of their client, and you're supposed to prevent unauthorized access or disclosure to third parties. Comment 19 notes that lawyers have to take reasonable precautions to prevent information from coming into the hands of unintended recipients, and both of these comments relate specifically to what security experts are doing for the legal profession as well as commercial organizations. A lot of the practices that we put in place in security are meant to help an organization understand how does the business work, how do we use technology to support that business, and then what are the potential interruptions or compromises or obligations that need to be considered. And the answer to those questions define the controls that you put in place. The primary controls that people want to think about, and the thing that I want you to take away from this conversation, is that everybody needs to look at your processes and your procedures for access control and the way that you're encrypting all of the sensitive data within your organization. If I control access to the environment and make sure that only authorized users have access to the environment, and then go a step further and make sure that only authorized users have access to the data, then we can argue that we have very strong protections in place, because the concept of least privilege and reducing the number of people who could see the data is something that we could argue for in our favor. Similarly, if I use encryption, encryption is your primary confidentiality control. And if we use the right approach to encryption, encryption is going to make it so that only the right people see the data. Now, the implementation of these controls requires some technical expertise, and there are all kinds of organizations that can help you achieve the outcomes that you want when you're doing authentication and access control, and the outcomes that you want to have when you're doing encryption. But you would be shocked to know how many companies globally don't have the right controls in place. And so this isn't just a conversation to attorneys, but it's a conversation to any small business. Small businesses, medium businesses, and large businesses alike, even some countries, do a horrible job of developing a plan for access control and identifying who are the right users to have access to different types of information, and making sure that information that is deemed sensitive or critical has the right protections in place, and also that that information is isolated somewhere within the environment. And so in some cases, you have an organization where all the data is on one computer, everybody can log into the computer, and anybody who wants that data can take it. And as you increase on the maturity scale, other organizations have the ability to segment their data. They distribute the data into different computer systems and different applications. And that distribution of data and the controls that they put in place allows the organization to control who has access and who can see it, because the simple implementation of access control, encryption, and segmentation have worked together to make it so that everything is, rather than being mixed together, is separated and isolated and controlled properly. And so the question that you would ask, if this was a live audience and I was standing in front of you as a class, the question would be, well, how do you define reasonable related to the reasonable effort that's described in comments 18? Well, there are all kinds of solutions that are in place. You know, as part of my research and as part of my preparation, I looked at everything that the American Bar Association had to say about technology. And great technology exists, but it's not an obligation, it's a recommendation. And so firms and organizations have to do an assessment to understand what are the features and the benefits and the capability of the technology that they use. You know, if you're a solo practitioner and you run your entire business off of a laptop, you have the ability to put controls in place to protect the data on your laptop, but the laptop is probably not the best place to put client confidential information. It would make much more sense to use a cloud service, to have that cloud service use multi-factor authentication so that you can guarantee that you're the only person that's logging into the service, and you store your data in a place where I can depend upon the service provider to put good protections in place, because you may not be an expert in digital security, information security, or just technology security in general. And so having those practices now allow you to say that you've taken reasonable effort because you put some thought into it. What happens in many cases is that organizations and law firms alike don't take the time to think, to evaluate, or to understand the risks that they're facing. And because they don't understand the risk, they don't have the right countermeasures in place. Now, one of the other things that's going to contribute to satisfying the requirement for reasonable is doing an assessment to understand what kind of data that you're dealing with. You know, are you dealing with sensitive information? What is the likelihood that the information is going to be disclosed? When we're defining sensitive information, what category does that fall into? Is it personally identifiable information or protected health information? You know, there's a extension of the rules and the professional conduct that come from the American Bar Association that leverages local and state requirements. And so within the United States, the National Conference of State Legislatures has specific rules that describe the reporting obligations and the requirements if there is a breach of personally identifiable information. You know, if you're a small firm that only works in Georgia, maybe you only have to know the rules for Georgia. But if you work across multiple states, every state where you have a customer who is a citizen of multiple states, you have to be familiar with the rules that are in place simply just for breach notification. And to avoid having to do the breach notification, you have to make sure that the right controls are in place. And so there is a different outcome if somebody has unauthorized access to a computer system, but all the data is encrypted and I can verify that encryption was in place and there was no access. And then you compare that to a situation where somebody accessed the data, I cannot confirm or deny what they looked at, but I can't prove beyond any reasonable doubt that there was no harm that would come to somebody because we have no encryption in place, and I have no auditing controls or any other technical capability to argue for or against how well do we do in stopping the criminal or the unauthorized person from gaining access to the data. And so thinking about your rules, your acceptable use policy, all of the policies and procedures and standards that go into the organization are not just going to protect you from a human resources perspective, but also start to describe the environment in which you're operating. You know, what is our corporate culture? What are we going to allow? What are we not going to allow? The answer to these questions start to influence the perspective that the organization has about security and the way your practices represent the perspective that you're communicating or exhibiting within the organization. You know, another area of interest that comes up very often, especially when we do consulting with large corporations, is that many companies say that I only want to spend money on compliance requirements because compliance defines my obligation. And once I've satisfied my obligation, I've done everything that I need to do. If you go a step further and you look at if you did a survey of all of the data breaches that have happened in the last 2 years, 85 to 90% of the companies that have suffered a data breach were compliant with the regulations that applied to their industry. And so if you go all the way back to 2018 or 2017 with Target and the data breach that Target suffered, Target was PCI compliant. PCI was the primary driver for the compliance program within the organization. And I'm not speaking for or against the quality of their security. I'm simply saying that many organizations, including Target, including Equifax, and including other major data breaches that you may have heard about, the organization met their contractual obligations or they met some regulatory obligation that they were subject to, but satisfying those requirements did not stop a data breach from occurring. And so it's very important that organizations understand the investments that you make in security are not going to prevent an attack or a breach. They are meant to improve your response when the worst happens, which is why we started this adventure with the conversation about SANS and the excellent performance that they demonstrated by identifying that the breach happened themselves instead of waiting for the FBI to tell them, and also providing remediation so quickly that only 28,000 people were affected rather than 28 million people. Now, of course, I haven't worked on SANS data breach. They were in the position where they could use their own students and their own employees to provide remediation. So I can only guess about the number of people that they have in their database. But SANS has been around for years and millions of people have their certifications. And so even if we just say that maybe 1 million people might have been affected, 28,000 is still a fraction of the number of people who could have been harmed. And they were able to limit that impact because they made the right spending or because they made the right investments. They spent in the right places and they considered what is going to be necessary for us to make the problem as small as possible. Now, if you go forward in the requirements that were listed by the American Bar Association and the conversation about what do you do before, during, and after a breach, the best answer is going to come from using a standards-based approach to develop an incident response plan and to have a plan for handling all of your actions within the organization once a breach occurs. And so inside of security circles, when you're not talking to attorneys, when you're not talking to business people, but you're talking to the individuals on the ground who are doing the work, the Computer Security Incident Handling Guide from the National Institute of Standards and Technology is one of the globally adopted and accepted standards that defines how to build a security incident response program. The idea that they take in NIST is that if you take a structured approach, you apply good governance and you put some thought and some planning into the process that you're going to use, everybody is going to have the best opportunity to reduce the impact to the organization when the worst happens. And so the idea with this presentation is that you're going to start with the preparation phase. The preparation phase is going to help you think about your policy, your procedures, your standards, and your guidelines for how you're going to respond to a data breach. Are we going to use our internal resources to provide the problem, or are we going to leverage a third party? You know, if we're relying upon a third party, what is the information that they need to provide us so that we stand up, that we pay attention, and we take the right steps? What are the steps that we're going to take? The answer to every question that you can conceive of is going to be developed in the preparation phase when you're documenting the governance for incident handling and incident response. The outcome of all of that effort is then going to describe your detection and your analysis capabilities. If we're doing it in-house, you're going to need a security operations team. That security operations team is going to require people, processes, and technology that allow the experts to monitor the environment for identification of a data breach or a cyber attack, and then to provide remediation once you have discovered that an attack has happened. As you move along the continuum and you move into containment, eradication, and recovery, the containment, eradication, and recovery are specific steps that you take to stop the incident from spreading, to remove the cause of the incident, and then to restore everything back to normal. At the end, you do your post-incident activity, and the organization is going to sit down and have a conversation about what happened, how did it happen, and how do we prevent this from happening again. Over time, the organization should develop the capability to go through the detection, the containment, eradication, and recovery faster and faster, so that you end up with metrics like the mean time to detect and the mean time to remediate. And those metrics represent the expediency with which we have identified a bad actor in the environment and how quickly we remove that bad actor and restore everything back to normal. You know, one of the things that I would caution you against is that the timeframes and what you describe as normal is going to vary for all kinds of organizations. You know, industry analysts say that it takes up to 270 days for most organizations to detect a bad actor in their environment, but 270 days is a long time to have a bad actor in your environment when you compare the existence of the bad actor with the obligations that firms have to provide incident response and remediation and to protect the confidentiality of the information that they're managing. And so the more effectively you do this and the more effectively you manage it, the better off you're going to be and the better off the organization is going to be. Now, the key phases in this, the detection and the analysis, is not something that your average person does. You know, even me being a security expert, I rely upon technical people to monitor the environment and to submit the incident tickets and provide remediation, but your knowledge of the requirements is what we're focusing on. You know, the objective of this conversation is to make sure that people are now aware of everything that they need to be concerned with. And with that knowledge, you can go out and start to put things into place that are going to support the success of the organization and are going to support the obligations that the ABA has said apply to all attorneys in the United States. You know, other things that you want to consider as we kind of draw towards the end of the conversation and drive the point home are really the threats that are faced by lawyers and what you should do. And in this part of the conversation, I know that we have people from all over the place. We have industry, we have professors, we have educators, we have practitioners, and we have attorneys. But the content in this part of the conversation is tailored and focuses specifically on attorneys and lawyers so that we can make sure that you know the right questions to ask and the things that you need to think about. Because this is a part of the Solo and Small Firm Committee at GAPABA, one of the most important statistics to highlight is that 66% of businesses fail after a cyber attack or data breach. The majority of the organizations in these statistics are small businesses, and the challenge is related to just business drivers. You know, if I'm a solo or small firm and my customers lose confidence in my ability to protect their data, the switching cost from going from one personal injury attorney to another personal injury attorney is not very high. And it kind of explains why Equifax can have a horrible data breach that affects more people in the United States than has ever happened before, but they're still in business. Equifax only has two real competitors. And most of Equifax support is a business-to-business environment where the customers had contracts in place and the contracts often didn't have a provision or a waiver or some kind of description for what do you do with my contractual agreement if the organization doesn't satisfy their cybersecurity requirements. Now, I'm very sure that when people are doing vendor management in the future, they're going to start incorporating that language in the contracts. But at the time that the Equifax data breach occurred, if somebody was a customer of Equifax, the switching cost is extremely high. And so now, years after the breach happened, the stock price is higher now than it was when the data breach occurred. For smaller businesses, you don't have that luxury because there are a lot of competitors that you have in the environment. And so with a lot of competitors, the switching cost is much lower, and a solo or small firm that has a data breach could lose a lot of customers because of the harm and the impact just on their reputation. And so it's in everybody's interest, if you're a solo firm, if you're a small firm, or even for the larger firms, for the AmLaw 100, investing in adequate protections and resilience capabilities are going to be very valuable because they increase the confidence that your customers have in the organization. Another problem is that phishing is the #1 method used by criminals to attack organizations. You saw in the SANS example, that attack was facilitated by phishing. With the Sing Health data breach, the attack was facilitated by phishing. Most of your attacks are going to be phishing attacks that come in, and the phishing attack simply requires that one person clicks on a link, or provides credentials because they think that the message is legitimate. And so making sure that you increase the awareness of your workforce with training and testing to reinforce whatever you're teaching in your programs is going to be very important. NIST, just like they have a guide for computer security incident handling, also has a guide that describes how do you build an education, training, and awareness program to make sure that your users are aware of the risks that they're facing and that they take the right steps. There are tons of vendors that will sell you security awareness training products. You can buy a product, you can get phishing training, and you can make sure that your users know what to do when they see a fake message and to whom they should report that information if you have the right procedures in place. But it doesn't always require that you buy something. It could simply be a matter of a fake message comes in, people recognize it as fake, you notify the rest of the workforce, and now everybody is aware that a message that is coming into the organization is not a real message, but is meant to trick you. For me, within my organization, we got a fake message about a fax, but we have a control that tells all of our employees when a message comes from outside the organization versus inside the organization. And so the fake message purported to be from somebody within the company, that header at the top of the message that gives a big warning banner in hot pink that says this is coming from outside, allowed the team to know that, no, this is not really coming from inside the company. We really don't have a fax that we're being notified about. And then they reported the incident. And so just increasing awareness by communicating with people and telling them what's going on and sharing with them things that you're seeing in the environment is a good free way to increase awareness of your staff and to reduce the risk that you're facing. Similarly, 85% of attacks are using compromised credentials. Sometimes the objective of phishing is to steal credentials so that you can use them later. Sometimes people are harvesting credentials from data breaches that happened in other places because users notoriously will reuse their password. And so there are very many situations where an individual, just a regular person, is going to use the same password to log into their corporate device, that they use to log into their bank account, that they use to log into LinkedIn. They're using the same password for Facebook. They're using the same password for Twitter. And if your username and password are compromised in any of those locations, the attacker can take the credentials and try to use them to break into other locations that they might be able to guess that you're a member of. Identifying what people are involved in is relatively easy because people like to share and say what they're doing. And so individuals know what I do as activities on Facebook. If my Facebook credentials are compromised, then they can try to use those credentials somewhere else. Or if I love my bank, or I love my attorney, or I love my church, and all of those locations have a website with the membership portal that I log into, the compromise of my credentials in one place could put all of my access to other locations at risk. And so the best solution to put in place to avoid the risk of compromised credentials is to use multi-factor authentication. So technologically, authentication is the technical process that you use to verify the identity of an individual. Very often, username and password is a simple and easy way to verify identities. But as you start to apply more things, like a fingerprint, where you send somebody a text message and they have to put in the PIN, or you have hardware tokens that are assigned to specific users, every one of those factors that you add to the logging in equation is going to increase the confidence that you have in the identity of the user. It is also going to prevent people from using the same credentials in multiple locations, and it reduces the likelihood that your compromised credentials could be used to break into the organization, to do a targeted attack, and to steal data. Similarly, most successful attacks are applied to weak computer systems. The Australian Signals Directorate, in conjunction with the Canadian Security Authority, did a study and discovered that 85% of targeted attacks are useless or are ineffective if you simply patch your computer systems in a timely manner. By patching, we're simply talking about seeing if there is an update to the software that you use or to the operating system that you use, and applying that update as soon as it's available. Now, in larger environments, if you're talking about a firm that has thousands of employees, the IT department is going to do this for you. If you're talking about a solo firm or a small firm that has fewer people, and you don't have a dedicated information technology team, it now becomes the responsibility of every individual to check for updates, to download the updates, to install the updates. But the time that you spend going through that process is going to reduce the time that you have an outage because your computer was infected or compromised or was damaged by malicious software. Not having an inventory of all of your systems and all of your data speaks directly to some of the rules from the ABA and some of the formal opinions where how do I protect something if I don't know what I have or where it is? And so completing an inventory of all of your systems so that you know what they are, completing an inventory of your data so that you know what data you have and where it exists, and then doing classification so that you assign a label to that data based on its sensitivity, its importance, or the obligations from a contract or a regulation that apply to that data is going to help the organization distribute things, put them in the right places, and then you can apply your protections to the most important data in the environment. Now, that is a hard pill to swallow for many organizations, and even beyond law firms, most organizations globally struggle with data classification and inventory, which is the reason that in most of your security standards, whether you're using NIST or whether you're using the International Organization for Standardization or any other approach, inventory and classification are high on the list of activities that you're going to perform as soon as possible to develop a security program and make sure you have the right countermeasures in place. We've already talked about incident response, but incident response is a specific obligation that was called out in the formal opinions. And so it's very important to highlight that inadequate incident response is going to increase the amount of damage that you realize when there's a data breach or a cyber attack or a security incident. If you compare and contrast the city of Atlanta that had a ransomware attack at the city level, yes, it was bad. Yes, systems were offline for days, but then you look at other cities like Baltimore and their incident response would be defined as inadequate because the result of cleaning up the security incident and the data breach that they had was not effective enough, and then they had another incident in a short time frame after that. Usually when you do effective incident response, you deal with the problem once, you provide correction, you fix the problem. But in organizations that experience a data breach repeatedly, over and over and over again, it is an expression that your controls are not effective or your response procedures are not effective, and it really requires some consideration about what are we going to do to fix the problem so that we are not suffering outages that are preventable if we just put the right controls and countermeasures and procedures into place. Another area that's going to be very important, and is one of the most important areas that are overlooked, is communication. We talked about the National Conference of State Legislatures, and the website ncsl.org provides guidance for how every attorney general for all of the states and territories in the United States wants people to be notified if they are citizens of the state. And so Georgia has a process, Alabama has a process, Florida has a process, all the way around the country. There are different processes, but the processes aren't uniform. Then you throw in things like the privacy requirements in Massachusetts and the Personal and the Biometric Information Privacy Acts in Illinois, and then the Consumer Protection Act in California, and you end up with a myriad of communication requirements and notification requirements when you have a data breach. The best answer is to put controls in place to limit the impact of the breach, but there's no way to prevent everything from happening. And so the idea that follows and is compatible with this is that you also want to have a plan for communication. The best way to communicate comes from the Center for Risk Communications, which analyzed 10 years of print and media coverage for emergencies, crisis, and just widespread disasters. And based on their findings, they came up with a messaging guide or a communication plan called the 2793 Communications Grid. Using that grid, what they propose is that the average length of a message should be 27 words. The average duration of the soundbite should be 9 seconds, and the average number of messages reported for a specific messaging campaign should be no more than 3. This ensures that your communication is clear, that it's concise, it has forced you to focus on the right problem, and it gives people information that they need to understand what's going on so they can take the right action. And so in our cybersecurity course, we go through this as an exercise, and one of the statements that we developed says as follows: The incident management capabilities we deployed successfully prevented an attack meant to disrupt critical services. We must remain on guard to protect the company and our shareholders. Now, that statement, if you look into the details, means that yes, we detected that there was a breach. Nobody was affected. There was no harm. We're paying attention. We'll give you an update when something else happens. Now, this could be a long conversation that adds confusion, which is what happened in the case of Target. It also happened in the case of Boeing when there was a discovery that data exfiltration was happening and people were stealing secrets that affected military vehicles. But if you can stay clear and concise and on message, and you give that message 3 times, even if you're communicating with the Attorney General for the state of citizens who were affected by the breach, people understand what's happening, they understand what they need to do, and then you give an update when you have more information. And you repeat that cycle so that you can control the message and people know what to do and what they need to know. And you're providing good information. Avoiding confusion is an important component of your incident response plan and the way that people are going to react based on the information that you're providing. The final item is really related to industrial and organizational psychology. And so law firms, corporations, universities are all types of organizations. And within organizations, the perspective of the leaders of the organization is going to have a significant influence on their perception of risk, the way they respond to risk, and the controls that they put in place to manage that risk. And so optimism bias, if we were to do a concise exploration of human behavior and psychology, is probably one of the most important concerns that you want to deal with, because many organizations, until they have suffered the consequences of a cyber attack or a data breach, feel like this is never going to happen to me. And so if I feel like nothing bad is going to happen, then I often take no action because I have limited concern that I'm going to experience a negative consequence or a negative outcome. And so my closing recommendation in all of this conversation is to say that even if you think nothing bad is going to happen, just in case, you should put a good plan in place. You should evaluate your data. You should do an assessment to understand the risk that you're exposed to. And you should make sure that the right controls are in place to protect the organization, the data that you have, and satisfy the obligations that you're subject to. And so as we move from this instructional portion into the Q&A session, and you're thinking about, well, what do I do now and what are my next steps? The first thing that I can encourage you to do is join GAPABA. Fabulous organization. I would not have hung out with them otherwise. For those of you who are running solo and small firms, they have great resources that are going to contribute to your success, not just from a security perspective that I've talked about today, but also to the practice of law and everything that you need to do to run your firm. If you want help from the experts, obviously I run a professional services firm. In honor of our support of GAPABA, we have discounted the rate that we offer, or the rate that we charge to do an assessment. If you need help and you need a 2-hour consultation that's going to help you identify the risk that you're facing and put the right countermeasures in place to manage that risk, we would love to help you out. If you just send an email to info@class-LLC.com and you put GAPABA security assessment in the subject line, it'll let our team know that we're offering you the discount because we love GAPABA, and this is one of the ways that we are supporting all of the members and the stakeholders of the organization. If you don't need an assessment, but you just want more information about cybersecurity, our next major event is going to be the Cyber Strategy Retreat. You can go to the website and learn more about the event. This will be relevant to a lot of attorneys because the International Association of Privacy Professionals is helping us deliver a very important roundtable discussion about privacy, focusing primarily on the California Consumer Protection Act. With that said, I will transition to the last slide. We'll open up the floor for conversation. And if you're an attorney who signed up for this, but you did not sign up on the right link to get your continuing legal education credits, please go to the link that's presented here so that you have the opportunity to get our gift of CLE in exchange for the participation that you had today. And so at this time, because I've done everything that I could to finish on time, we'll now open the floor up for questions, and I'll give it over to Daniel to facilitate our Q&A session.
All right, thank you, Keyaan. So our first question comes from Neely Shah. She's the GAPABA treasurer and owner of her own successful trust and estates firm. Neely?
Hey guys, how are you guys?
Doing good, how are you?
Good. Thanks, Keyaan. I was very educational. I have a lot of notes here. So my question is, I mean, I'm a solo practitioner. What would you say is kind of the first step, for somebody that does not have a formal plan in place? I mean, you've taken all the authentication measures and the cloud security, but if you suspect a breach, what would you say should be, your step one? What action should be immediately taken in notifying all of the clients?
Well, one of the things that we say in security circles is you never declare a breach until you have confirmed that it's a breach.
Okay.
One of the reasons for that is the word breach from the National Conference of State Legislatures perspective has a specific meaning associated with it. So in their definition, breach means that you've had unauthorized access or disclosure of sensitive information. And their term for sensitive information is really personally identifiable information. And so if personally identifiable information has been breached and you verify that, you really should notify the Attorney General for the states of all the people who are your customers or constituents. If you're only a Georgia attorney or a Georgia firm, fortunately, you only have to notify Georgia. But if it's other citizens in other states who are your customers, it's very important to make sure that you follow the processes that NCSL has, and it's very important that you follow the process that the Secretary of State in those states have identified. I mentioned Massachusetts, Illinois, and California because they probably have the most stringent requirements, but you really don't want another state coming into Georgia and fining you because you didn't satisfy your obligations for protecting their citizens. And so after you do your notification, again, this is at the point that you have confirmed that there has been unauthorized access to the personally identifiable information or protected health information if you're a personal injury attorney and you have people's healthcare records also. Then you want to kind of go into the process of containment, eradication, and recovery. Hopefully you have backups. Backups are one of the best things to have because it's going to allow your business to survive a security event or a security incident. Prevention would really be a better strategy. You can prevent being subject to the breach notification requirements for a much longer time frame if you encrypt all your data. And so I know your question was about what's the first thing that I do, but if we rewound a couple of steps, I say the first thing that you want to do is encrypt all of your sensitive data. To make sure that that takes place, you have to identify all your sensitive data. And then maybe if I only have one hard drive, because I'm a solo practitioner, on the hard drive, I'm gonna have at least 2 different folders, and one folder will be for sensitive information, one folder will be for non-sensitive information, and then there are hundreds of tools available to encrypt data on a folder on a computer system.
Yeah.
Now, if something happens to the computer, you can say, I have a high level of confidence that there was no unauthorized access to the information because I have this encryption system that is commercial grade, military grade, whatever you want to call it. But most encryption solutions, if they're valid solutions, are going to prevent that data from being disclosed. Now it just comes down to, did I configure it properly so that there are no problems with the data?
Okay, thank you.
All right, thank you, Neely. We have a question from Cynthia Lee. She's the professor of law at George Washington University. Her question is, are there any good tutorials that walk people through things like how to use encrypted emails and whether it's worth the trouble to do so, and how to protect against hackers besides not clicking on links from people one doesn't know?
Well, that's it's a complex question. The best answer is that there are numerous organizations that provide security awareness training that cover most of these questions. You don't have to get a university degree in cybersecurity to learn all of the best practices to address the problems that we discussed. You have companies like KnowBe4 and EC Council has an OFISH product, but there is a long list of products that you can just purchase a training kit, and the training kit is going to notify your users of everything that they need to know. There are industry organizations that will come in and do training. Like the Information System Security Association is a collection of security practitioners that attorneys can join as members. There's a chapter in Atlanta, there's a chapter in DC where our professor is, but there are chapters all over the place, and the awareness is built simply by spending an hour a month or maybe 2 hours a month just hanging out with professionals. And then you can ask people directly, and you don't really have to spend a lot of money or hire a consultant or a service provider to do this for you. You simply have increased awareness because you're hanging out with the people that do this for a living.
Thank you. Next, we have a question from Melanie Dowse. She's the president of the Association of Corporate Counsel and most recently general counsel of Rota AdviseX. Hi, Melanie.
Hi, thank you very much for this. I have a two-part question. The first part is what are the top 3 cybersecurity incidents you're seeing now that people are working from home? And the second part of the question is, how does that differ from what you're seeing before when people were in the office?
Oh, great question. So if we answer your second question first, the difference between now and then is that before, I think it was March of 2020, 27% of people were authorized to work from home. And then you get March of 2020 on forward, and 90% of people globally are now working from home because of the isolation that we're trying to use to flatten the curve. And so you've had a drastic shift in workforces, and most of those companies that did not plan for a remote workforce don't have the right security protocols in place to support remote working, which now leads into answering your first question second. Insecure remote access is probably the number 2 threat. The number 1 threat is phishing messages. And so if we don't have something like a virtual private network, you imagine my wife and I have 5 children. 3 of them are still in the house. Between the 5 of us that are in the house right now, we have all kinds of people on the internet doing different things. Some people are playing video games. Some people are doing schoolwork. If I allowed my corporate work to intermingle with all of the communications in my house, it's going to increase the likelihood that I have some kind of problem. And so what we tell a lot of people to do is set up a virtual private network so that the worker, the breadwinner, the employee of the company, has a secure channel to connect to the corporate office, so that now you have all your corporate protections. Otherwise, everything that your home network is exposed to could affect your corporate device. And if you have sensitive digital information on your laptop or on your remote device, is now exposed to everything that you're dealing with. And this is even worse for people who live in apartments, because now it's not just a small case where it's me and my family, but it's me and my hundreds of neighbors are all in the same vicinity of each other, and bad security with any one of them could cause a compromise of my data in that type of scenario. And so I would say virtual private networking is a really good tool. Secure remote access, there are all kinds of other solutions that instead of putting the data on the employees' laptops, the employees are using their laptop to access corporate data that is still in the corporate environment, that is still protected by all the resources. And then the other things that we talked about, the encryption and the access control, are going to contribute to that. But the moral of this story is that the drastic shift from working in the office to telling people to work from home, there was no plan for that. And not having a plan is what is leading to the success with the increase in cyber attacks. The attacks have always been there. They're just now more successful because it's weaker, easier targets to compromise when people are sitting at home, or, you imagine that millions of people are now working from Starbucks instead of working from their corporate office. It's a very different environment from a security perspective.
Thank you very much.
Thank you, Melanie, for your question. Next, we have a question from Judge Bill Duffy. He is a former U.S. District Judge in the Northern District of Georgia. His question is, for a lawyer in a small practice, for example, 1 to 2 lawyers and 3 administrative employees, how do you identify qualified, efficient security providers to address access and authentication for an environment like the one described? And what is the range of costs? There's a second question to it. Is there a need to have the provider of these services provide continuing services after the protections are put into place?
Yeah, the answer is going to fall into 2 categories. One of the things that you want to answer, and so I'm answering Mr. Duffy's question, but the answer applies to everybody. Question number 1, what do you really want people to do for you? If they're doing the implementation of technology, that is going to be a different type of service provider compared to somebody who is going to help you build a strategy and put a security program in place and maybe document some policies and procedures. Under normal circumstances, you want to work with specialists. Like if I needed a personal injury attorney, I wouldn't go to a family law attorney. I'd go to a personal injury attorney. That same concept is going to apply with your security providers. You want to seek out people who specialize in the thing that you're looking for. And the really good firms are going to be able to recommend somebody else that you work with. And so if you hire a policy firm, they're going to know who are the good people that can do the technology management, and vice versa. If I hire good technology management firms, then they're going to be able to recommend good people to help me with the policies and procedures. What I would say is it's the same thing that you're doing if you're hiring employees. You know, interview the firms, ask for references, talk to people that they've worked with. That is really the only way that you can evaluate, is this a good match for me? If you just go on the internet or you look at the Better Business Bureau, there are thousands of companies that do something that would fall under the category of cybersecurity. And so it becomes important that you have a conversation with them, you understand what their capabilities are, and you talk to a few of their customers so that you can have a level of comfort that they're going to provide the right level of service for you. The other thing that you might do is just do a Google search for data breach plus the name of the company. Security firms get breached too, just like we gave with the example for SANS. And so any information that you can learn about their security practices and are they practicing what they preach is going to give you a little more confidence. The final thing that I would say is the terms of the contract are also going to be very important. You want to look at the statement of work and the agreement that you have with the provider and make sure that they have said, you know, what are we doing? How are we doing it? How long is this relationship going to last? And as your security provider, especially if they're providing technology like security operations and incident response as a service, you want to understand what are the triggers, what are they actually going to do when something happens at 3 o'clock in the morning on a Saturday? Are they going to be available, or do you have to wait until 9 a.m. Monday morning, as long as it's not Labor Day?
Well, thank you. And thank you, Judge Duffy, for your question. Looks like we have one more question. During the pandemic, have you seen any trends in how cyber attacks are presented, especially in the form of emails? Our office has received emails proposing great deals on personal protective equipment and cleaning services. We have not responded or opened any of the attachments or links. I'm curious to see if you have seen any attempts, successful or not, that take advantage of the fears and vulnerabilities exposed by the COVID-19 pandemic.
Yeah, that situation that was described is exactly why I said that phishing attacks have gone up by 650%. I mean, that was not hyperbole. That was a mathematical statistic. And the entire outcome is based on campaigns that focus on fear and uncertainty and doubt and panic. And so the attackers are leveraging people's uncertainty and their concern about COVID. I think 5 times a day, I get at least one message about masks or something else related to COVID. If you have the right protections in place for your email provider, they can filter out a lot of those spam and phishing messages, because those messages are really just, they're categorized as spam. It's difficult. There's a CAN Spam Act that kind of reduces the amount of unwanted email that you're supposed to get, but it's hard to keep up because it has gone up globally with the COVID-19 pandemic. But if you tune your email solutions so that they catch the spam and that they're not accepting messages from fake senders or it's not a legitimate company, it's going to reduce the number of messages that you see in your inbox, which ultimately reduces the number of opportunities that your staff, your employees, and your attorneys are going to have to click on the wrong message and trigger some type of data breach or another cyber attack.
Great. Thank you for that, your answer. Next, it looks like that's the end of the question. If anyone else in the audience has any question, they can feel free to provide it in our chat right now. We'll give you a minute or two just to see if there are any. If not, I'll move it over to Jung-wook to close out the presentation.
Thank you, Keyaan, and also Daniel, for putting up this very informative and relevant webinar, and also to our Bonnie for providing all the support, and for Wizardry in terms of Zoom meetings. I just wanted to highlight other GAPABA functions that are upcoming. As you know by now, GAPABA is hard at work providing informative and also fun events throughout the COVID lockdown. I would like to highlight 3 events that are coming up. One is the Asian American Breaking Through the Hollywood, which is taking place on September 9th. And then on September 15th, we have the Women's Leader Network providing a webinar and also CLE on parenthood, womanhood, and the profession. And then last, not least, but the service committee is providing volunteer opportunity with ABLF. And this is an opportunity where both students and also attorneys could train in diverse areas where we're helping low-income community members who would otherwise not be able to obtain attorneys. And also, as Alan mentioned, the Solo Small Firm Committee is looking for passionate and dedicated committee people to take over for this position for next year. So you could email me and Alan at sf@gapaba.org to show interest. So thank you everyone for participating, and remember to sign up for your CLE credit.
All right, thank you for everyone.